What is your interpretation of the Marbury v. Madison case?
Well, I think it's the most important case in American jurisprudence because, it goes way beyond whether Marbury deserved to be a justice of the peace in the District of Columbia. What it did was it set forth the checks and balances, the third part of it, which was not laid out in the Constitution. Who checks the Senate? Who checks the House? Who checks the legislative branch? And if the legislative branch and the executive branch are in line and the president signs the bill, who checks the two of them? Okay, for the first time in this case, the Supreme Court reached out and grabbed judicial review. And they said, the law is unconstitutional, therefore it's invalid. Every single case that follows Marbury versus Madison is based on that judicial review. So I think it's the most important case in the history of American jurisprudence.
When you think of the Supreme Court, the first thing you think about is the power to declare laws unconstitutional. The term for this power, the main check that the court has on both legislative and executive branches, is judicial review. Technically, judicial review is the power of the judiciary to examine and invalidate actions undertaken by the legislative and executive branches of both the federal and state governments. Marbury was born in Piscataway, Maryland. Named after his father, Marbury spent most of his early life in Maryland around his home. William Marbury was a highly successful American businessman and one of the midnight judges appointed by United States President John Adams the day before he left office. In an effort to prevent the incoming party from dismantling his Federalist Party-dominated government, Adams issued 42 judicial appointments, including Marbury's issue as Justice of the Peace in the District of Columbia on March 3, 1801, the day before he turned his government over to incoming President Thomas Jefferson.
Why do you think that Adams wanted to keep the Federalist Party strong by appointing so many midnight judges?
The Federalist Party was dying out at that point. Republicans and Democrats were being elected to the Senate and to Congress. He tried and offset the growth in the Democrats and Republicans in Washington.
James Madison Jr. was born at Belle Grove Plantation near Port Conway, Virginia, on March 16, 1751. His father, James Madison Sr., was a tobacco planter who grew up on a plantation, then called Mount Pleasant, in Orange County, Virginia, which he had inherited upon reaching adulthood. Madison had been a delegate to the Confederation Congress and wanted to be elected senator in the new government. A vengeful Patrick Henry wanted to deny Madison a seat in the new Congress, so he ensured that Madison remained in the lame duck Confederation Congress to prevent him as long as possible from campaigning. But when Thomas Jefferson was inaugurated as president in 1801, he named Madison to be his Secretary of State. Marbury was an official that President John Adams, at the very end of his term, appointed as Justice of the Peace. When Marbury went to get his official commission certifying that he could start his job, James Madison, who was Secretary of State, refused to grant it to him. So Marbury went to the Supreme Court for a writ of mandamus that would force Madison to grant Marbury his job. This is what he was supposed to do according to the Judiciary Act of 1789. Chief Justice John Marshall used three key pieces of evidence in the Marbury v. Madison case. Chief Justice John Marshall presented the case as raising three distinct questions. 1. Did Marbury have a right to the commission? 2. Do the laws of the country give Marbury a legal remedy? And 3. Is asking the Supreme Court for a writ of mandamus the correct legal remedy? The first piece of evidence that Marshall used was that Marbury's commission had been signed by the President and sealed by the Secretary of State, establishing an appointment that could not be revoked by a new executive. The second piece of evidence that Marshall used was that Marbury was entitled to a legal remedy for his injury, citing William Blackstone's commentaries a general and indisputable rule. Finally, Marshall stated that the judicial law for a writ of mandamus was unconstitutional.
What cornerstone cases have been affected by the establishment of judicial review?
Oh, every single case. Brown, you look at the three cases based on ethnicity in this country. The first one being the Dred Scott case, then Plessy v. Ferguson, where in Dred Scott, Justice Taney said Mr. Scott wasn't a citizen because he was of African descent, therefore didn't even have access to the court. Then you look at Plessy v. Ferguson, where the proposition of equal, separate but equal was constitutional. And then the seminal case, of course, is Brown v. Board of Education, where the court reached out and said that the mere separation of the child stigmatizes that child, and therefore the child, or the stigmatization itself is unconstitutional. None of these cases could have been reviewed and decided without the principle of judicial review, which was established in Marbury. And you can see the migration of thought of the Supreme Court from the Dred Scott case all the way to Brown v. Board of Education.
Marbury versus Madison is arguably the most important case in Supreme Court history. It was the first U.S. Supreme Court case to apply the principle of judicial review, which is the power of federal courts to void acts of Congress in conflict with the Constitution. Written in 1803 by Chief Justice John Marshall, the decision played a key role in making the Supreme Court a separate branch of government equal with Congress and the executive.